Okay, longer. Now say before we adjourn plan, you say Namcor never got to use and enjoy the assets, and by that I'm referring to the service stations. Is it correct?
It's saying they cancel the contract. What happened?
Now, so is it correct that the agreement was actually cancelled on 14 September 2023?
Yes.
In fact, the document that is on the port bundle says the document is dated 13 April. The document that has the index that starts from page 1 to 5, but I'm referring to the last document on page 189. That's actually from 188. Yes, but now I'm more interested in the fact that look, from the time you signed the agreement up to the 13th of September 2023, Namcor actually never enjoyed the use of the property even after you had sold it to them. Is it correct?
It would be good if you ask the representative of Namcor where they did enjoy that services.
I'm asking you, the one that sold the items to them.
Yeah, but it's not me who was on our side. We never blocked the usage of Namcor to make use of those facilities. So it would be good if you find out from those who were representing.
Now, I want to take you to the bundle that was given to you by Mr. Namanje. The one that starts from 194, if I'm not mistaken. What day? The one that starts, the index starts at 190. Page 192. It relates to Enacon account number 8023531520. Are you there?
Yes, sir. Yes, sir.
I want you to check. That document is from January 2022, 7 January 2022, 28 November 2022. Do you see that?
Yes.
And I want to be specific, the date of 12. Yes, 12 July. 12 July, transaction code 11155. You see that?
12 July, yes.
And the balance was 7,397.55 cents. Do you see that? On the right side, the balance in the balance column.
The balance 1.5.
No, in the balance column, sir. On the right side.
37,000.
Yes. Do you see that?
Yes.
Now, do you see that on 19 July 2022, 35 million came in, which came from Namcor Trading. Do you see that?
Yes.
I want to tell you, do you see if there was any other money that came into that account apart from the money that you got from Namcor? From the 19th of July up until 28 November 2022.
Yes, from the credit side, yes.
Yes, but that amount, which amount specifically?
Are you talking about after the amount went into the account or prior
Yes.
to the?
You see, I'm saying, let me break it down. I'm saying you did not receive, you were saying you were receiving money from GRN for the fuel supply to NDF.
Mhm.
But from those transactions, the only amount that I see of the money that you received from GRN was 696. On 18 August 2022, transaction 106.
Mhm.
But now I'm putting it to you that it actually shows the question that I put to you earlier, that there was actually no money, enough money for you to pay the debt from the date that Enacon owed to Namco. Apart from the money, the 53,212,000 that you received, and you then thereafter sent or paid back the money, the 35 that you received.
Mhm.
Yes, there was no money. I'm saying there was no money. You actually used Namco's money to pay Namco's debt. That's what I'm saying.
No, there is money that has been coming in. There are entries, the credit that has come in the account.
On this account,
Which, I'm confused, I'm not an objection, which Namco money used by my client, my colleague is talking about? I just, before I could, which Namco money is my colleague saying you used Namco money to pay Namco?
Understand. He was referring to 35 million paid from Namcor.
Yeah, but the client, before that, but he must be fair to the proceeding and to my client. Before lunch, your worship. Your worship, you can look at your note. The client attempted to say that, and the client said that is our Enacon money as part of the purchase price.
What is the objection?
I'm not objecting.
You are not objecting.
He was confusing me by saying it's not Namco's money. There is evidence on record, your worship.
say, did you have any other money in this account that you used to pay for the debt that you owe to Namco? Apart from the 35 million you got from Namco, from the 53 million, did you have any other money that you paid towards the Namco debt? Did you?
There is an amount that has come in.
No, I'm asking you whether,
Yes.
which amount did you use to pay the debt of Namco? From your own money, apart from the 35 million.
Enacon money, there are transactions that come from a separate Enacon account that come into this joint account. These are the amounts that are meant to pay Namco. Or I don't know what is your question. Because the debt, the credit, there is amount here coming in 2,500,000.
No, that's not what I'm asking you. What I'm asking you is, apart from the 35 billion that you got from Namco, from the sale of the assets, from the 53 million, is there any other amount that shows that you actually, from this account, pay any money towards the debt of Namcor.
The amount that Enecon was receiving from the Ministry of Defense was used to pay Namcor's debt and their transaction to that.
So, did Enacon continue to supply fuel to the Ministry of Defense after the 18th of July?
Yes,
But you say the agreement was cancelled because you had actually,
My client never spoke about an agreement cancel. My client never spoke about an agreement cancel. Which agreement was cancelled?
the fuel supply agreement.
Then you must identify we are dealing with hundreds of agreements because you just came from the Ministry of Defense. Then you say the agreement was cancelled. You are confusing.
It was a premature objection. Did Enacon continue to supply fuel to the Ministry of Defense after the 18th of July?
yes,
The fuel agreement.
yes.
Okay, but then is it correct that Enacon then when it sold the assets to Namcor, that was before the 15 years encumbrance of the assets?
No, it's not a 15-year contract.
15-year agreement,
Yes,
but then as per the agreement was valid for 15 years, you agree?
yes, until 2021.
But then the agreement that you signed with the Ministry of Defense was the fuel supply and storage.
Take your time.
The last one is at page 140, the 143.
On the bundle that starts with page 1 to 5, I'm taking to page 144. That is the memorandum of agreement between the Ministry of Defense and Enacon. I'll refer to it as the first bundle.
Okay.
What is the page?
144.
Yes,
Let me start with the point that says, whereas Enacon is 50% owned by August 26 Holding, a state-owned company. Do you see that? Yes. So, you agree with me that Enacon was not 100% owned by you?
yes,
In 2016, when you signed this agreement with the Ministry of Defense, when Enacon signed the agreement with the Ministry of Defense,
yes. There was an arrangement, there is an agreement between August 26 and NF.
yes, the document says so. So in other words, you could not sell the assets by you. I'm not referring to you in your personal capacity. I think going forward, I'm referring to Enacon. Enacon could not sell the assets without the permission of the other 50% on.
No,
I just clarity. Is that taken from the agreement or is just a proposition given from what is in the docket of the court of agency to the witness. If it is taken from the agreement, my colleague must first refer the witness to the provision.
I think it's common knowledge, and I'll refer to the document itself. Because if something is 50% on, and the agreement also says, it's unfortunate that Mr. Namandi was not here this morning. When I refer to the clauses in the agreement. Specifically page 164.
Okay. 164. Your
But I have not even gone through the why this is rising. Yes, where it says each party acknowledges that this agreement, because there is no one party to the agreement. That's what I'm saying, each party. So that is what I'm putting to the witness, that the discharge from that agreement would not be done without first having informed August 26, which was a 50% honor in Namcor.
With respect, it's very, very low. And my colleague is contradicting me. Initially, Your Worship, he said, when I said, is he taking it from the docket or is he taking it from the agreement? Remember, on the basis of the parallel evidence room, the integration room, the agreement is the exclusive memorial of what the parties agreed. Now, my colleague is saying NDF or the ministry, through whatever their entity is a representative, is a 50% shareholder in Enego. That is exactly the point. You see at page 143, the ministry is represented by Brigadier General J. Awara. You see, he signed on behalf of Enego. So he's already in, the ministry is already in Enego. If you look at page 143, your worship, you see that it says Enego, Namibia, duly represented by the chairperson of Enego, Mr. Peter Erindi, and the director of Enego, Brigadier General, retired J.B. Awara. He's representing the other 50% shareholder. But that's not the point. Where does the agreement says there must be information to the ministry? That's what I'm asking. If he says he's taking it because there is a witness who told ACC that that is what was supposed to be done, they have two problems. The first one, that will be contradicting the terms of the agreement. So in other words, it will be inadmissible because you cannot read extraneous evidence, because the part of evidence says the agreement is the best agreement. It is the best evidence, your worship. But if he is taking it from a witness in a witness statement, then he must say it is his instruction, so that when I cross-examine Mr. Inambao, I will then take him on, who is saying that it's against what the agreement is saying. For instance, if he says a witness told him that they must be informed, I say, but where is that witness taking it when the agreement does not say that? So with the greatest respect, and my colleague should not be thinking that we are being obstructive when we, on a basic thing, we are standing to protect our client. James Awara is there, representing Ministry of Defense in Enego, if that is the point he wanted to raise.
No, Your Worship, I think that the accused can answer the question. Here is my context. I'm saying this agreement says each party must notify the other. And if Your Worship, if you have regard to the document on page 51, which was an asset party, 51 years. That is just an agreement that is entered into with Namcor without that Brigadier Awala's involvement. So that's why I'm saying the agreement here says it's 50% owned by the Ministry of Defense. And it's true, Brigadier Awala was present when the memorandum was signed. But the point I'm arriving at is to say, in the asset purchase agreement with Namcor, Brigadier Awala was not involved. In fact, it's just Peter Elindi, Malaki Elindi, and Emmanuel Mulunga of Namcor. So I'm qualifying the question.
But Your Worship, what is he trying to ask? Where does it say Mr. James Awara must be part of any agreement that is to be signed on behalf of Namcor? When he says the agreement says the other party must be notified, what is he talking about? That is all what we are asking. Which provision? He must take us to that provision so that I can see if he's misrepresenting what the agreement is saying to my witness, to my client. So what is he trying to say? Is he trying to say this agreement says that if anyone wants to buy a car, Maraki Arindi must be there, Arindi must be there, James Awara must be there. Is that what he's trying to say? So he must refer the witness to the particular provision so that we will see whether we send it to the witness.
Worship, I'll do this again. That's the beauty of having these documents in front of me. In fact, I did that this morning. But let me do it again. I'll start with the document that starts on page 143. And specifically page 164. Are you ready, Your Worship?
Yeah.
I did that this morning, paragraph 12.1, and I was specifically referring to no modification, consent, or discharge in connection with this agreement shall be, it says, or its provision shall be binding upon either party unless made in writing and signed by the parties so to be charged with the same. So that's why it says made in writing, and also I qualified that with on page 166, breach and termination. Which talks about either party to the agreement having to give written notice to the other. It says without prejudice to any other remedies which either of the parties may otherwise have in terms of the agreement, either of the parties shall be entitled to terminate the agreement by written notice to the other in the event that the alleged breach has firstly been referred to arbitration. So all I'm saying is that there was no written notice. That's why I'm trying to get.
Then I see where they close the meeting. And my colleague, with respect, he appeared to, first of all, he's contradicting himself. The clause 12 that is only talking about the manner of amending the agreement between the two parties. My client, not my client, Namcor and MLB. It has nothing to do with accession of right. Remember, Your Lordship, cession is something different. And it has nothing, it regulates that if you are amending, this is the manner of you amending it. If there is a discharge, and my colleague is confused, he thinks a discharge means termination or walking away. It's a discharge from obligation. If you were supposed to pay me within 12 days, and I give you a relaxation, that is what it means actually. So so it deals with amendment, and it's a basic, anybody who has moved, who has been in a class, law, contract, commercial law, knows this kind of provisions. The breach, none of the charges faced by client has anything to do with the breach of the agreement between MOD, Ministry of Defense, and ENECO. And my client did also not allege that the ministry or my client breached the agreement. The notices my colleague is talking about, those are notices only between Ministry of Defense and ENECO if there is a breach. Or we want to terminate. But my colleague appeared to be, with respect, to be confused because he's thinking by telling your right that you have as against the Ministry of Defense, title and right, he's thinking the agreement has disappeared between ENECO and Ministry of Defense. So he's confusing cession of right, transferring the right, something not prohibited in the agreement. With variation is something else with respect. So I must also protect my client because since this is a court of law, when something is wrong in law put to my client, he must stand up. In fact, the court should be the primary protector of my client. When does a variation clause become a termination clause?
I'll move on. I think the documents are self-explanatory. I'll move on from that aspect. In fact, I'll say I am in possession of a statement which the investigating officer will come and testify to the effect that the executive director of the ministry says that ENACOM never communicated its intention to the ministry to sell the concerned assets. What is your answer?
It's the right and with respect to the assets that ENECON built in the military bases were done based on the agreement for which the executive director is aware. So we were not required by any agreement to consult the ministry if we were to undertake such items. In fact, everything we were doing here was going to be done in the best interest of the ministry.
So, but this asset did not belong to you, because that's why the ministry took offense with the fact that you sold them without informing them, without their consent. Why would they take issue? If
They belong to ENECON. ENECON built those facilities.
In the premises of the Ministry of Defense, but yet you are saying they belong to ENACOM.
It's an industry practice that when you build your asset within somebody's premises, the asset refer to pumps and tanks and other facilities. Those facilities belong to ENECOM, not to the ministry. And those are the assets that we are referring to.
Where is the agreement, or where is the title deed that shows that those those assets belong to ENACOM?
Yes. Can my colleague stop saying hi when I speak? He cannot make some statement with
Yesterday he made a reference to prosecutorial above.
Yes, can we have?
Yes, I apologize.
Yes.
Yeah, please, I will not, your worship, my colleague is saying, your worship, You know,
I'm listening.
did he say a title deed? So he's referring to a title deed of the registrar of deeds title deed. Oh, that's all what I wanted, and he did not mean to insult. All what I wanted to say is it a title registered by the registrar of deeds in respect of pumps and tanks? Is what? Is he referring to a title deed that the Ministry of Land, if he can just clarify?
Well, I'm referring to a document that loosely put a document that shows that they were the owners.
Yes, that is exactly why I stood it. Now he's saying a document, because the title deed of transfer, if he's referring to that, then I would say, okay, but those are not, it's not land. People are talking about pumps and tanks. So now he's saying a document. Why did he not just ask, where are the documents showing that you are the one that purchased the title? Then he must say document, your worship. It also clarified that my standing up also clarified the matter for the court.
Yes, so where is the document, if any, whatever you decide to call it, where is the document that shows that you were the owner of the assets?
I indicated already, and I informed you already, said that I informed you that there is an asset register that was provided, which described the items that are part of that transaction between Enecon and Namcor. I said this is probably the fourth time I'm saying that.
So on the document that I've earlier on referred to, the asset purchase agreement, do you see a signature of Brigadier Awala there? Do you see it there?
Brigadier Awala was representing August 26 holding, and at the same time, he is a director in Enecon. August 26, not when they obtained the 50%, discharge their obligation, their financial obligation to buy the 50%.
By discharge, what do you mean?
They did not pay up.
No, I'm asking you, what by discharge, what do you mean?
No, I've changed. I'm saying they did not pay up by plan.
All right, but the question related to, is there a signature or a name of Brigadier Awala on the asset purchase agreement between Namco and Enacon? Is there his name there? Does it appear?
No, it is not there.
Okay, why is that?
Even if you go by, you earlier told me about company law, Enacon had 3 directors, and 2 of the directors have signed that make up the quorum.
But say, these assets were not just owned by you, but by Enacon alone. Why was it necessary to include Brigadier Awala in the memorandum between Enacon and the Ministry of Defense, but not to include General Awala with the asset purchase agreement?
That's why I'm saying certain items, certain processes took place at that moment when we were finalizing, when that asset purchase agreement was taking place. There were issues between Enacon and August 26, whereby the payment that August 26 should have paid to Enacon was not paid. So this is completely different. That's why I'm saying, even if that was the case, it was sufficient for me and Malatia to sign because we need have the quorum.
Maybe before we proceed, just for the record, on the rules of the memorandum, it says the Ministry of Defense was represented by Permanent Secretary Mr. Peter Ship. And you keep referring to Mr. Awala representing Minister of Defense. But Mr. Awala was representing Namcor on the memorandum. Thank you, Your Worship.
Thanks, Your
Because there are two people here you have mentioned that, which document is the court
That is the
referring?
memorandum at page 143.
Is it on top or where is the court
That
referring?
is page 143.
Yes, there is Peter Elindi and James Awala there.
The Ministry of Defense, my concern is the Minister of Defense. It says represented by the Permanent Secretary, Mr. Peter Shibu. Because I hear you say Ministry of Defense was represented by Mr. Awala. On this document, the Ministry of Mr. Awala was representing Namcor. Yes.
Okay. Well, this that is made, I think there is nothing laughable about that. I take Mr. Casper, please, I will not like your comments.
Sometimes can we get the collegial one another? Proceeding as easier, so let's take the proceeding.
Yes. Your worship, despite that, if that was an omission on my part, even the name of Peter Shibute is not even present in the agreement, the asset purchase agreement.
He was deceased by the time of the contract.
Well, no one from the ministry was involved, despite it Namcor 50% owned by the Ministry of Defense. That's the point I'm trying to arrive at. Is there anyone from the ministry on the asset purchase agreement?
But, Your Worship, that's why did you bring a commercial case to criminal court? Your Worship, when you, although
Mr. Nomande, that's an objection.
it's an objection. Yes. Your Worship, my colleague keeps saying, where is the Ministry of Defense on the asset register? A company, a PTY, is comprised of a capital, a share capital. A share capital authorized maybe 4,000 shares. If it is 50-50, August 26 has 2,000, Peter Erindi has 25, Marakia has 25, it makes up 4,000. Together, indivisibly, they form a legal persona. So that when the company goes out and enter into an agreement with Namcor, there is no more speaking about shareholders individual. It's the company. So the share register anyway, as far as we know, corporate register, accountants verify that they were company secretariat. With respect, my colleague is wrong to continuously say, where is the Ministry of Defense signature on the asset register? That is not an asset register of the Ministry of Defense. By the way, the Ministry of Defense was never a shareholder directly in Namcor. It's a private company called August 26, although owned apparently by Ministry of Defense. So it's unfair, it's wrong to continue asking my client an impossibility. If the agreement, let me just say, Your Worship, if the agreement between my Namcor and the ministry stated that whenever Namcor is to sell its right to the asset, the Ministry of Defense must have a representative, then my colleague could. So without that, he's not entitled to say that if it is the Namcor, it could be Marakia, it could be somebody else, it could be an accountant, it can even be a lawyer representing Namcor. With respect, honestly, why was a commercial case brought to criminal court so that there is a complete misunderstanding of corporate law?
Any comment?
No, I have no comment. Yes. Worship, my premise of the question is based also on the statement that we are in possession of the executive director, Mr. who says they were actually disappointed. In fact, it says it is important to note that Namcor Namibia had never communicated to the Ministry of Defense and Veteran Affairs of its intention to sell the concerned assets.
So you are, what I want to know, do you stand on your question?
Yes, I stand on my question.
Yes. Then the objection is overruled. Do you have any comment?
It's simply to say, Enecon as a private entity was not required, and there was no agreement to that effect, that if it has to enter into an agreement, any agreement, including that one of the asset party, would require a consent from the ministry. That's my answer.
So
That is my answer. Yeah.
you had earlier on testified, probably yesterday or Monday at the start of the proceedings, that you wanted to recoup something there. What was that? What did you want to recoup from the sale, if I can get you correct?
Which says,
You say you wanted to recoup the money that you had spent, correct me if I'm wrong, for the construction of the home-based fuel stations on the premises of the Ministry of Defense. How much did you want to recoup? Let me start with.
is that with regard to our agreement with the Ministry of Defense, or is with respect to the asset purchase agreement?
With the ministry.
We were recouping the investment, the amount we have spent in setting up the facility, building the facility.
But your agreement as at 18 July 2022 with the ministry was still operational, is it correct?
Yes,
The one of 15 September 2016.
yes.
And then how much did you recoup at the time that you then offered to sell the assets to, and Enacom decided to sell the assets to Namcor?
I would not go into the amount we recoup. The only important thing is a period of 15 years was given, within which period Enecon should recoup the investment, the amount we have put in the facility. I think the important thing here for us is that within that period, let's say if we put 53 million, I get 58, actually put 58 million. That amount, whether we recoup it exactly by 58 or we make more money and receive 70 million, it's a business transaction. So as long as the amount that we borrowed, that we made the arrangement to set up those facilities would be recouped, that was the basis of the agreement. And there is no misrepresentation that we did that.
Your agreement was set to come to an end in 2031, is it correct?
Yes,
But then you decided to sell the assets before even the 15 years, before even 2031, is it correct?
we sold the right title that we had, since in fact Namcor offered to buy the right and the title that we had on those fuel stations until 2031.
But you sold the assets before 2031, that is my question.
Yes, it's a business transaction. Remember, we were the one taking care of the asset. Apart from building them, we were the one in charge of technical maintenance, environmental.
I would like to stop you there, it's fine.
Can my colleague let the witness complete?
Well, the answer, I got the answer already.
But-
Whatever he's
The
explaining, I'm not
witness has not
interested.
completed what he was saying. Can my witness be protected, Your Worship? The witness has not completed what he was saying.
We have not completed the part of the question. But did you get what you wanted?
Yes, I did.
You have anything apart from?
No, sir.
So at the time you offered to sell the asset, well, I just want to move away from that aspect. At the time that you wanted to sell the asset, when you offered to sell the asset with Namcor, your agreement with
Excuse
them,
me, sir, when Namco offered,
yes, and you accepted because you got the 53 million. Your agreement with the Ministry of Defense was still standing, was still valid. And you went ahead and you received the money.
Yes.
53 million.
yes,
And then just want to find out something from you. So from March 2016 up until July, March 2022, March 2022 to July 2022. Were you in a fuel supply agreement with Namco? Where you buy fuel from Namco? Were you in an
Yes.
agreement? Did you pay for the fuel that you were receiving from Namco?
yes, we were paying. We were paying.
Do you have documentation on your bank account then? Specifically, what I'm referring to page 192, the bank statement of Namcor Pty Limited. Can you show me on that document, starting from actually January, 7 January 2022, 28 November 2022? Can you show me which transaction relates to you? Or let me break it down. Let's start from January, 7 January to July 2022, transaction 107, where the one actually transaction 155, 12 July. Do you see that? Can you show me which amount from 7 January to 12 July went to Namco pay for the fuel that you are buying from them?
I think we should just go the transaction start right on top there, from January to January to February, and then we have the one in May. Yeah, the transaction that came from that came from the Ministry of Defense into this account, and that account is a this account like this.
No, my question was from 7 January 2022 up until 12 July. I asked you to check if there is any amount that you paid for the fuel to Namco. I'm specific with the date, 7 January 2022 to 12 July.
Let's see, 7 January here.
On top, it's the
Oh,
first
yeah,
date.
yeah, 7 January.
Yes, from that period to 12 July,
Yeah, they are.
which amounts went to Namco?
All those amounts that are there in that credit column, they went to now.
where does the reference Namcor appear that you show that you are actually paying for the fuel to Namcor? Because I have GRNEFT and Namcor Namibia, which can you show me or tell the court which amount show that you are paying for fuel to Namcor?
4,954,900. That is an entry on the 20th of January 2022.
But the description there says GRNEFT.
Yeah, that is the transfer. The transfer from Ministry of Defense, and this is in terms of the agreement as well. Remember, the agreement was saying between Enecon and Namcor, the one in March was saying that Enecon is obliged to ensure that the transaction go into this joint account, which is the account that ends with 520, the purpose of the agreement.
No, you are misunderstanding me, and I think you are deliberately misunderstanding me. But I'm saying, I'm very specific. I want to find out from you if there was any money you paid for the fuel you were getting to Namcor, because that description you are giving there is saying GRNEFT. So that's what I'm asking you. Is there anything that says Namcor there?
That money is coming through a purchase order coming into this account. That's the money going to me.
So are you saying the description or reference number of Namcor is GRNEFT?
Because the account, this is a joint account between Enecon and Namcor. And that is in terms of the agreement that was signed, the fuel supply agreement in March.
Maybe before you proceed, just for the record, and assist if I am wrong. In terms of the agreement, there was a joint bank account which the money from the Ministry of Defense was to be paid into, where Q3 was a co-signature. Yes. So
It's important that you accept that accused 3 was co-signatory on behalf of Namcor.
Namcor, yes. So when Ministry of Defense pays that money goes into that joint account for the purchase of the fuel from Namcor through this act. So I'm not sure. Maybe with that, I will clarify whether I don't know whether I put it.
Yeah, you did correctly, and really this is a thing. What it appeared to be confusing my colleague.
So, yeah, maybe before, I want to know whether his question is centered on that aspect.
Exactly, that's what I'm saying. I'm just also clarifying. What is bringing the problem? My colleague is trying, he himself. First of all, your worship is 100% correct. It's an account in the name of Enecon, but it's a joint account. A safety measure was introduced so that, for instance, you can transfer because the executive of Namcor is on that account. So it's joint, notwithstanding the name being Enecon. Now, the problem is coming because my colleague appeared to think if the transaction does not, the amount that are going up, if it does not say Namcor, for instance, say Enecon Namibia, as if he works there, he appeared to say that is not going to Namcor. And,
Yes.
and he didn't ask the witness whether, why is there such a description?
So, Counsel, I want you to see whether with that picture, can you now take us to your question? Whether it's different from that, then go on.
Well, all I'm saying is that even if the money, I don't work at the bank, so I do not know why the description of NGR and EFT. I don't know, but I'll just move on to a different question. Because I do not understand the nature of the objection, because for me, I'm seeking to understand.
I don't know whether maybe I just put it just for the record, to clarify. That's why I asked that council, you must assist, seeing, I'm listening to the question, that you want in on this statement, for example, to indicate the amount paid by Enecom for the purchase of fuel from now.
Yes.
Yes, that was the question.
Yes.
Now, his answer is that, and it's very honorable, that in terms of the agreement, there was a joint agreement in which Article 3 was a co-signal to make sure that that money from the Ministry of Defense, which is for the purchase of fuel from Enecom, goes straight into the account. So that Article 3, on behalf of Namcor, is control over that account. So that money, even though it appears as GRNEFT, was paid in terms of this agreement by Enecom to Namcor.
All right.
Yes.
I understand. It's fine. I understand. So now, sir, can you tell us if from the 16th of March up until July, you were getting fuel from Namco?
Which year?
2022.
That is page, is that?
From the bank statement.
Yes.
The same document on 192.
What was your question?
Yes, I'm asking whether from 16 March 2022 until 16 July, you were paying for any fuel you were receiving from NAM.
Until
16 July.
yes,
Where is that?
there are transactions here in credit. There is a 1.4 million, 1,420,000 that went to Namco.
Was you say that the investigating officer will come and testify that from March 2022 to July 2022, you were getting fuel from Namco, which you never paid for, which totaled the amount of 70 million.
That's negative. Incorrect.
In fact, the investigating officer will come and testify that you were actually getting fuel for free from Namco. You were not paying for it. It was just given to you for free.
This question, Your Worship, this debt-related question that there was a supplier of product, you failed to pay. Investigating officer is coming to say you failed to pay. So in other words, on which charge does it relate? Because I do not know any offense in Namibia if you do not pay debt. My colleague referred to 70 million. If he's talking about 70 million, the charge, Your Worship, is not about failure to pay. The charge, can I ask the court to go there with respect? These questions are irrelevant. And everybody will be shocked that an investigating officer of ACC goes around asking who paid debt. That's not what we are here for. The charge is at page 40, it's 40, count 40, page 70. And this is what my colleague is attempting to do, but he's missing it. The charge, Your Worship, is whereas the accused did between October 2022 and December 2022, and remind you, Your Worship, that period in the bank statement, page 192, that period is different. The accused person, they committed fraud in that he entered into a fuel supply agreement to purchase fuel from Namco and agreed to receive funds from the Ministry of Defense and Veterans Affairs in Enecon's account, then the account is given, an account from which Jennifer Anquire, accused number 3, was given signatory power in the said agreement in order to transfer the fund received from the Ministry of Defense, while in fact the said funds were being received in a different account. So the charge why we are here is not about debt correction. It's about apparently my client committing fraud by telling Namcor we will pay in the account where Jennifer Anquire is the signatory and we pay in a different account. The second part of the allegation is B. It says that he agreed that all purchase order issued by Enecon to Namcor shall be accompanied by a government purchase order for the same products and quantity with invoices stipulating that the fund will be deposited in that account, and that this was not the case. So the fraud charge is not about failure to pay debt. It's to mislead Namcor to say the fund will be paid in this account, and to mislead Namcor to say our invoices will stipulate that you MOD must pay in this account. It's not about debt correction. So the questions that are being asked with greatest respect are commercial, are irrelevant. There is no such an offense.
Your Worship, there is nothing commercial here. If just to show to the court, this relates to the conspiracy that instead of paying the conspiracy between the accused and the employees of Namcor, he was getting fuel for free, and then thereafter when he sells the fuel, he is paying it. So
Your Worship,
It is not finished.
I understand, Your Worship, but when a colleague rises, the other colleague must say. I'm simply doing
I'm
this.
just saying that he's not finished.
I
Maybe
understand.
let him-
I understand, Your Worship, but equally so. By implication, when my colleague says employees of Namcor, they are there, Your Worship. I represent some of them. It's only fair that my learned friend clarifies and says, when I'm saying employees, I'm speaking about accused 2, 3, or 4. That's all I want, Your Worship.
Yes, no, I understand, but at one point he was not finished.
the employees of Namcor is accused 1, 2, 3, and 4. Those are the ones I'm referring to. So it's just to show the conspiracy that despite the fact that fuel was received, in other words, if I can say received for free by Enacon, an entity represented by the accused, he went on then to conspire with them in order to pay them bribes after he had paid for the fuel. In fact, I'm saying these charges are not complete. I do not know why my colleagues are actually
Madam, can you just, yes.
writing here. These charges will be added. We are not at trial now, so I do not know why counsel for the accused person want to restrict us strictly to the charges. They well know very well that charges will be added.
No, your worship, we ask you with greatest respect to protect us. We ask the court to keep the standard applicable in this country. The standard applicable is that you don't arrest an accused person and go and think out what to charge. You bluff around and say we have a strong case for charges that the accused person was never informed. For purposes of bail application, your worship, it's true the state can investigate and may as well discover some more charges, but that is a speculation we do not know. But for purposes of bail application, that's why your colleague, your worship, ordered the other day that we must be provided with the charges that the state has arrested our client on, and they placed our client in court, and they are objecting bail on those charges. So now my colleague is saying, is talking about when, if I did not stand up and object, he would have gone on talking about a commercial debt correction. When I stood up and objected, he has now diverted himself. He's talking about a conspiracy Conspiracy is the crime. It's not like common sense, which is a concept by which you can run together accused person. Conspiracy is an offense. Now, my client, your worship, yesterday I took you to the charges where there was
Just get to the point.
the point is, your worship, is that he is not entitled to ask irrelevant question, otherwise we will never finish. We are not in this court. There is no charge against my client that you committed fraud because you said you are able to pay debt and you did not pay. There is no such a charge.
Okay, then you make your point and then the court.
And the last one, if there is a conspiracy offense, so that I know, so that when I re-examine my client, I deal with re-examination, knowing what my colleague was referring to. Then my colleague, your worship, must tell you which conspiracy charge against Peter Erin is he talking about among those weakest charges I went through yesterday. Your worship, we are not being obstructive. We want this proceeding not to turn into a huge irregularity. We want fairness.
Worship, as you said, we equally have a duty to protect the accused persons. You cannot allow the state to play hide and seek, worship. They cannot invite us on one invite, and as they go along, they change the invite to become something else. That's the bottom line, worship. And as you said there, worship, we have a constitutional duty to protect the accused persons from such conduct.
May please, Your Worship. Your Worship, I rise to make just one point. Your Worship, I wish to invite you please to look at the grounds of opposition so that we can once and for all deal with the issue of the charges can be amended later. One of the grounds of objection is seriousness of the offense and the strength of the state's case. Your Worship, what that means in these proceedings, not in future, not tomorrow, not yesterday. What that means is the court, after we are done with this entire exercise, and especially before some of our clients come and testify, the court will have to look at what is the charge. What is the testimony or the evidence that the state will bring in future in support of this charge as it stands today, in order to assess whether indeed the strength of the state's case is as strong as it is, so that this court will fear that if our clients are convicted one day, when they are on bail, they will not return to face the possible sentences and what the type of sentences that they may face, whether it's a fine or whether they will be incarcerated for a long time. That does not take away from the fact that charges can be amended at a later stage. But for these proceedings, the charges cannot be moved, and you can't say you're going to amend in future, because the determination that must be made in this proceeding is a simple one. Is the strength of the state's case really as strong as it is? And for that, you need to know what the charge is, not what the charge will be in the future, not what the charge will be tomorrow, not what the charge will be when the PG makes the decision. So we are not looking at whether they can convict in the future. We are looking at today, or when the court decides whether or not to grant bail to people that have not yet been convicted, whether the charges, the state case is indeed serious offenses first. Secondly, whether the case is indeed strong on those charges. So it does not help for the state to say they can amend. Nobody is disputing that the state can amend at any time. But for these proceedings, these are the charges we are faced with. So that is the point I have to make, Your Worship, and it's a very important one. Let's not lose sight of what the nature of this proceeding is, and that it only speaks to one ground, not what we think should be evident, but that specific ground will need us to know what the charge is, whether it's a serious charge, and whether indeed the evidence that is being proposed to be laid in future is of such a nature that it is strong enough to at least secure conviction.
Yes, Your Worship. Just one contribution on behalf of my clients accused 1, 3, and 8. it's actually it's very scary for the state to stand up and say in a blanket, statement saying that the witness was getting fuel for free. And he says because he was paying a bribe to accuse number 1, 2, 3, and 4. But Your Worship, if you look at the charges against number 1, there is nothing indicating that he received any bribe from anyone. If you look at the accused number 2, the same. Because when some other juristic entities, Quality Meat, Parkwood, whatever you call them, those are entities who are not before the court for purpose of this bail application. Then number 2, Your Worship, if you look at it, page 65 of that index, which goes from page 1 to 5, that is a binding contract between Enacon and Namcor, in terms of which Namcor, as a seller, undertook to supply fuel products to Enacon as a buyer. And if there is a problem, there are provisions to that effect. If you don't pay, there is a remedy to that effect. But for the state to stand up and say a witness was getting fuel for free, he was distributing money, paying bribes, it's, Your Worship, this is a court of law. The court of law deals with the evidence before it, not to just statement, irrelevant with a statement being made without any support by any documentary evidence before the court. Please, the court, Your Worship.
This is a bail application. The charges have been already disclosed to the accused, to their counsel. This is a bail application. And we know the court is going to face with the issue whether the applicant before court is a good candidate for bail. That is what the court can do. The rest of the other issues can be dealt with in another court. Yes.
All pieces. Now,
Your Worship, maybe to respond on behalf of the case number 2, based on the ruling of the court, so there's the state now leeway to ask any question without any facts. Because bail applications in case law dictates that they cannot stand up and make a sweeping statement. It must be backed up with facts. So I'm a little bit confused as far as the ruling of the court is concerned. Can the state make mere allegations and the court would accept that? Because at the end of the day, the court must just get whether or not the applicant is a candidate. But the state is now allowed to make sweeping statements.
Mr. Maybe before you proceed, the court is not saying the state must make sweeping statements. The court is saying can we restrict ourselves to the issues we are dealing with.
On the
Yes.
facts.
Yes.
Okay.
Yes.
So noted.
Yes.
As the court is.
That is what the court is saying.
As the court
Don't
is.
put words in the court.
No, that's not what I'm saying.
That's not what you think. I did not understand. But I'm saying, can we deal with the issues we have?
As the court is.
We understood the court to say what is relevant, what has happened before.
Yes. We can proceed.
my request short back on break.
We are already at about in. We can finish it. Yes. Short bathroom break, 10, 15 minutes, will be already almost 60.
Just
5 minutes.
Because I'm considering whether it's worth taking a 10 minutes break or we just roll the matter.
Yes. You should to the court, perhaps to adjourn it until tomorrow, because I really needed to use the document.
Your Worship, we can allow my colleague 5 minutes. No harm will befall any of us if 5 minutes is afforded. so that we can make good use of the remainder of the financial.
Okay.
So, God bless you.
That is in order. Report.
Remain seated.
account of Enacom Namibia Pty Limited. The account number is 8023531520. Can you show me on that document, the bank statement from January up until November, where you made any payment to Eco Trading?
This account is a joint account between Namcor and anything. So there is no way there can be transaction that relates to.
So can you show us, if you are saying it's a joint account between you and Namco, can you show us on which bank statement you were paying for the fuel to Eco Trading? I'm in possession of the two statements, but I just want you to show us both statements of
I'll
Enacom.
have to look for it. I don't have it right here. I'll have to look for it. Not right here.
Your worship, if my colleague doesn't have an objection, just to clarification, page 193, the continuation, that is the account that ends with, you remember your worship yesterday, to avoid confusion, I stopped so that I do not mislead court, that is part of 520.
Yeah.
That is 848. And if you look at my colleague, if he doesn't, because I'm not changing anything, if you look down, your worship, on the 19th of July, my colleague must look around there.
Can you show us?
Is it page 193? Yeah.
From 193, do you see anything? Payment made to Eco Trading.
Just because
No, I can't see any. I don't see anything here on the credit.
And so, did you pay for any fuel to Eco Trading?
Enacom had more than this account. It could be that if we set the account, we will be able to find paying this.
How were you paying for the fuel you were getting from Eco Trading?
What do you mean?
Are you paying cash, bank transfer, or how?
No, it's always bank transfer.
Do you have an explanation why it's not showing on the bank statement?
No, with respect to my colleague then must first lead the witness in respect whether my colleague is leading the witness as if they have produced the total statement of Eco Trading. What they did, they took an extract. Then he must first lead the witness and identify a document and say, in front of you, you have one page or whatever taken from either Enacom or whatever. If he has a full bank statement ever of Eco Trading, he's entitled to say, your bank statement does not show payments to to eco trading, particularly, Your Worship, in view of the evidence. Remember, you were told by the witness that the relation started from 2017, and that agreement and so forth, Your Worship. I think it's just fair for anybody reading the record that it's just an extract for a certain period, and it's not the whole statement of my client or eco trading.
Well, even to the slightest degree, I did not hear him saying they paid. So that's why I want him to answer. I understand, yes, it's just part of the statement that was disclosed, but from the statement that we have, there is nothing that shows that there was any payment. So it's up to him to answer.
But then, when you first email of the day, and he said we had more than one account.
How many, we have the 848 and the 520. How many other accounts did you have?
Well, I will have to verify. That's why right now, as you ask me, I won't be able to give you a correct answer. I will have to verify. You will have to verify.
Well, I'll put to you that there were only two accounts of Namcor. The other account, if you have it, bring it, but I'm putting it to you that from what we have, there were only two accounts, and there were no fuel payments that were made to eco trading.
I'll have to verify this account.
And in fact, I'll put it to you further that the only amount that was paid in the account of eco trading is the 9.5 million that you got as a result of the sale of the assets, which was further laundered. It's the only amount that we can see that you paid to eco trading, no other amount.
There have been amounts paid to eco trading. There are.
Then what plausible explanation do you give that the money that was sent from Namcor Namibia to eco trading owned by Victor Simaneka Malima was distributed almost at the same day, different accounts? What is your explanation?
I you can't answer the explanation when eco trading in Victor Malima is a different person. But when we made that payment when Namcor made the payment to eco fuel, that was to procure for fuel.
Is it eco fuel or eco trading?
Eco trading.
So I put it to you that the reason why this money was spent or distributed the way it was from eco trading to quality meat was to launder it and as well as to pay for the bribe, and specifically with regard to the employees of Namcor, accused 1, 2, 3, and 4.
I object to that. First of all, we have now already established, Your Worship, that there is no such charge that these accused persons are facing before the court at present. This court has already ruled that we should confine ourselves to the facts before this court. On what preposterous proposition is my colleague making this ludicrous statement he's making to this witness, Your Worship?
Any comment?
Well, there is nothing. I'm sure he knows our stance still remains that these are preliminary charges. I think if each person can answer, he can answer. Not for counsel to answer for him. If he has no answer, he can say so.
Any comment?
It's just a problem that he keeps repeating, asking me transaction that have to do with eco trading when I have already clarified that the transaction that we transferred, Namcor transferred to eco trading was for the purchasing of fuel. Whatever happened later, thereafter, I don't know. Just like I said, most of these names here, quality meat and all other names, I'm hearing them for the first time during this proceeding. I've never heard of things like that. And Victor is a person with his right to deal with all what he received in his account.
We can proceed.
Just to conclude on this aspect, so what explanation do you give? In fact, from 1 April 2024, the statement of Eco Trading, I think that statement is with the report. Account number 800653483.
What is the
Yes, what explanation do you give that I went through this statement. There are no transactions that show that you are paying for fuel actually with paying fuel to Eco Trading.
We have paid fuel to Eco Trading.
Yes, can we move?
Your worship, my query must.
Can
Please.
we move on?
Okay, your worship. We didn't have this document for days. When we were brought to court, we were given this document and we were complaining. My colleague now just continue saying there are no transaction. This is their own document showing that Namcor paid Eco Trading. Your worship, it's misleading because it came from a senior advocate of the High Court. Look at page 4 of the same document. There is, of course, that 9.5 already that he spoke about. But move to the next page, page 5, your worship. On top there is the 1 million paid by Namcor. 1 million. Why is he telling my client only got this document I never consulted my client on this document. He's only getting it under cross-examination, no time to prepare.
Yes.
With respect, it's unfair for my colleague to suggest his own document to say there are no other transactions going into the account of Eco Trading from there. And
Your point is well taken.
exactly.
We can move on.
I still have some aspect to cover with this because I see it's 10 minutes.
Very action time for the court to Jan, the matter is then rolled to tomorrow. You are still under. You can start at 9. The court starts at 9.
Your worship, there was an issue today. The main reason why we didn't start at that. We're not going to go into who was here, but the accused persons were not here at 9. We understand that it's a different office that deals with us, but the bulletin order can be given to them. Because they only arrived way after 9. That is the main reason why we lost that 1 hour that we wanted to make use of.
Court starts at 9. The matter is set down for 9.
That's the code.
Okay.
Please, the continuation.